Good evening, everyone, and welcome to my Legal Current Events Pecha Kucha, presented to you by me, yours truly, Natasha Hunter. In 1965, a group of parents and students sued the St. James Parish School Board in an effort to desegregate their schools. The court sided with the parents and students and in 1967 enforced a desegregation order for St. James Parish. Fast forward to 2016, Greater Grace Academy applied for and was approved by the Bessie Board and the Louisiana Department of Education to become a Type 2 charter school. But in order for their final approval to happen, they must obtain federal court approval since St. James Parish was still under the desegregation order from 1967. Obtain the final approval that they needed, Greater Grace decided to attach themselves to the 1965 lawsuit. The board and the group of parents and students opposed Greater Grace's efforts, stating that if they wanted to operate their school, they should have to comply to the deseg order. The board approved Greater Grace's request, causing the current appeal by the 1965 parties. So let's stop. Let's remember why we're here. Remember, for final approval to happen for Bessie and LDOE, Greater Grace must obtain approval from a federal court before they can operate. However, according to the Louisiana statute 17:3991C3 states without the federal approval, Bessie could not approve the school's contract and the Department of Education would not provide funding. So Greater Grace attached themselves to the 1965 lawsuit solely for the purpose of petitioning the court for permission to open their school. A few weeks before school was to open, Greater Grace filed a motion to operate their school, promising to comply with the deseg orders that were established. To expedite the process, Greater Grace filed a motion to expedite consideration from the court so that they can receive state funding. On the same day that the court approved Greater Grace to operate, the 1965 parties filed a response arguing that Greater Grace should be subject to the desegregation order under the statute. The district court approved Greater Grace to operate for three reasons. One, failure to not open the school deprived students of school of their choice. Two, Greater Grace attracted a diverse background of students. And three, the district and other schools within the district were already 90% Black students. The 1965 parties argued that the district court did not thoroughly analyze all of the relevant facts and that allowing Greater Grace to operate violated the desegregation order under the Louisiana statute. However, during this appeal, the Supreme Court decided on another case, Town of Chester, New York versus Leroux Estates, that states that any party that comes before the court must have their own individual reason to appear before a federal court and not just attach themselves to another issue. This means that regardless of what was previously argued or approved, Greater Grace could not attach themselves to the 1965 lawsuit. For this reason, this case was sent back to the district court because Greater Grace did not establish their own reason